Hello, I'm Bradley Supernaw, and I'm an attorney in Nebraska, and this is part 2 of the most frequently asked questions about getting a divorce in Nebraska. As I mentioned in the first part, a little while ago, a few days ago, well, at this point, a couple weeks ago, I was playing around with ChatGPT to see if there was anything that I thought I could use it for in my practice. And one of the things I did was ask it, what are the most frequently asked questions about divorce in Nebraska? So according to ChatGPT, these are questions 11 through 20 of the most frequently asked questions. Again, I have my notes with me, the questions, and some notes on some of the questions. These answers, like the first video, are going to be kind of short, so there may be some topics that will require a separate video to cover them in more detail. And as always, this video is for informational purposes only. It is not intended as legal advice. If you are in the middle of a divorce or you are thinking about a divorce, I would encourage you to speak to a family law attorney, especially if you are outside the state of Nebraska. The answers to these questions might be a little different. So question number 11 kind of picks up where question 10 left off in the last video. What is equitable distribution, and does Nebraska follow this principle in divorce cases? As I mentioned in response to question number 10, equitable distribution basically means that it's fair distribution. It does not necessarily mean equal distribution, although most of the time that's what's going to end up. It's going to be as close to 50-50 as possible. And equitable distribution, again, we're talking about splitting the marital property. There have been some cases in Nebraska where the distribution, depending on the facts of that particular case, have been 2/3 going to one spouse and 1/3 going to another spouse. And the courts, the appellate court and Supreme Court in Nebraska, have held that those are equitable under the circumstances of that case. Again, it's going to be very fact specific if it's going to deviate from the normal 50-50 or as close to 50-50 as possible. What happens to debts incurred during the marriage in a Nebraska divorce? Like marital property, marital debts will be divided between the two spouses. Generally speaking, if a debt is secured by property, for example, a mortgage or a car loan, the spouse who gets that property is responsible for that debt. Sometimes debts can be distributed in a way that will help even out the marital property in the equitable distribution. So, for example, if one spouse is getting a property that has a high value or high equity, and they can take on additional debt in order to kind of even out the distribution. How does Nebraska handle retirement accounts and pensions in divorce settlements? This can get kind of complicated. The marital property, generally speaking, is any property purchased during the marriage from income during the marriage. So that would include a retirement account or a 401k or an IRA. What gets complicated about that is that a lot of times one spouse will have, or both spouses, will have a retirement account before the marriage and they want to keep it after the marriage. Sometimes that can be done through playing again with the assets and with the debts to kind of even things out so that both spouses just keep their retirement accounts. Sometimes, though, you have to figure out what is that portion of the retirement account that is marital property and equitably divide that portion of the retirement account. And since the decree is an order involving the two spouses and it does not involve the whoever is managing the retirement account. A lot of times in the situation where the retirement account is going to be split, it'll often involve what's called a qualified domestic relations order, a QDRO or QDRO. And that's just an order from the court instructing the manager of the retirement account how it's going to be divided. Sometimes that can be as a lump sum at the beginning, although that can also depend on the retirement account itself. Sometimes that can be in the form of receiving retirement benefits once the spouse who has the retirement account retires. What factors does the court consider when determining child custody in Nebraska? Now, this is one that I had to take a lot of notes on because there are a lot of factors involved in determining child custody, especially if it's the judge that has to make that determination. Child custody is based on what is in the best interest of the child. The best interest of the child is defined in statute, and there are certain statutory factors that must be considered. What's written into the statute that the court must consider are the child's relationship with each parent, the general health, welfare, and social behavior of the child's preference, whether there is credible evidence of child abuse or neglect, and whether there is credible evidence of domestic intimate partner abuse. Just a real quick note on the child's preference. In Nebraska, there isn't a particular age that the court will take into consideration the child's preference. It depends on the maturity of the child and the reason why the reason they can give for their preference. And that's not going to be a determining factor. I've seen situations where a child as young as 12 will talk to the judge about what they want. And generally, the judge will talk to them about other things, not just, well, do you want to be with this parent or that parent? I have seen situations where a judge will take into consideration the preference of a child as young as 12, and that can be a big part of what the judge's decision is made. I've also seen situations where children as old as 17 will give their preference, but the judge does not agree for whatever reason and makes a determination other than what is the child's preference. So it can be a factor, but it's not a determining factor. There are some other factors laid out in the case law that are not part of the statute that the court will also take into consideration. And these include the moral fitness of the child's parents, and this can include the sexual conduct of the parents, the respective environments offered by each parent, the emotional relationship between the child and the parents. I guess that kind of goes with the child's relationship with each parent, part of the statute, the age, sex, and health of the child and the parents, the effect on the child resulting from continuing or disrupting an existing relationship. Again, that goes with the child's relationship with each parent. The attitude and stability of each parent's character, the parent's capacity to provide for the physical care and to satisfy the educational needs of the child. Those are the non-statutory factors, and a lot of them do tie into the statutory factors as well. You'll notice that I didn't say the income of each parent. Income is not a factor. What types of child custody arrangements are available in Nebraska? Again, the child custody arrangement is based on what is in the best interest of the child. However, it can be very flexible, especially if it's something that the parents agree to and that the parents agree is in the best interest of the child. And especially if the parents live in the same town, so that the child is in the same school district and able to participate in the same activities. You can have something that is 50-50, and 50-50 can be 1 week with one parent, 1 week with the other parent. 50-50 can be Monday and Tuesday with one parent, Wednesday, Thursday with the other parent, and alternating Friday, Saturday, and Sunday between the two parents. Um, you can have where the child is during the week with one parent, every weekend with the other parent, or every other weekend, and you can have the child spend most of the child's time during the school year with one parent and most of the summer with the other parent. It's very flexible, especially if the parents can get along and come to an agreement. Again, it has to be in the best interest of the child, although if the parents agree that something is in the best interest of the child, a lot of times the court will go along with what they agree to. How is child support calculated in Nebraska? Child support in Nebraska is calculated according to the Nebraska Child Support Guidelines. They take into consideration a lot of the economic condition of both parents, their income, whether they have other children that they support, whether they've been ordered to pay child support in another case for another child. It takes into a lot of factors. It can also, if there's joint custody, and joint custody can be, 40% of the time with one parent, 60% of the time with another parent. It can take into consideration how much time the child spends with each parent. Is alimony awarded in Nebraska divorces, and if so, how is it determined? Alimony, which is sometimes called spousal support, is not very common to be awarded in Nebraska. It can be part of a property settlement, for example. A lot of times when it is awarded, it's because one spouse needs a little bit of time to kind of get back on their feet, to kind of maybe finish education or go back to school for something, or to get their career restarted if they took a time out from their career, especially if they took their time out of their career to raise children, for example. Usually in those situations, spousal support is temporary. A year, 2 years, 18 months is not uncommon if there is spousal support awarded. But again, spousal support is not terribly common in Nebraska. Can I modify child custody or child support orders after the divorce is finalized? Yes, both can be modified, both custody and support, if the situation changes. To modify the custody order, the parent seeking the modification will have to show that there has been a change in circumstance such that if it had existed at the time of the original order, the order would have been different. So for example, if the parents were living a couple hours apart, so they did an every other weekend sort of situation, and then they end up moving into the same town, you might be able to modify based on the change of where the parents live, where the child lives. Child support is a similar situation as far as modifying child support, but with child support, again, it's going to be change in income of either one parent or the other parent. The change would have to be such that it would either increase or decrease the child support by at least 10% or at least $25, whichever is greater. Also with modification, if you're seeking a downward modification, it has to be from an involuntary change in circumstances. For example, if you lost your job and you had trouble finding a job, or you ended up finding a job that paid significantly less because you couldn't find a job that paid the same as before. If, for example, the parent paying child support was employed in a position that had a high income and decided, well, I don't like paying all this child support, so I'm going to quit my job and become a cashier at the local convenience store. Well, that's a voluntary decrease in income, so the court is unlikely to modify the child support in that situation. What should I do if my spouse and I can't agree to the terms of our divorce settlement? This kind of depends on what you're having an issue with. If you're having an issue with child custody, Nebraska requires that you attempt mediation. Nebraska has some good mediators. They're neutral third parties. A lot of times they're lawyers, but not always. They're not there to give legal advice. They're not there to make a decision about one way or the other, how custody should go. But they're there to help the parents communicate. They can help keep the tempers low. If necessary, they can split the parents into two separate rooms instead of having them in the same room. That way they can kind of moderate the words that are being said so that they don't insult one parent. One parent's insult to the other parent doesn't get said to the other parent. And a lot of them have been through a lot of mediations, or as private practice attorneys have handled a lot of child custody situations. So they know that things can be very creative. So they may have some ideas that they understand what the concerns are or the desires are of each parent. They can help them maybe think of some things that the parents might not have thought of originally. And that can help them come to an agreement. If the issue is on the property division, you can attempt mediation on that. It's not required. It's not very common. A lot of times those will end up going to court, sometimes in pretrial hearings or status hearings. If the judge knows what the issue is on property division, they can kind of signal how they normally rule in those situations, and that can kind of help nudge the two spouses toward an agreement. But if there just is no way to come to an agreement, then ultimately it will end up in front of the judge, and the judge will make a decision. If mediation on the child custody is also unsuccessful and the parents still can't come to an agreement, then again the judge will ultimately be the one to make a decision. And finally, the 20th question: how does mediation or alternative dispute resolution work in Nebraska court cases? Well, I kind of mentioned this in response to the previous question. Mediation, again, is required in a case that involves custody if the parents aren't able to come to an agreement on their own. Mediation involves a neutral third party who helps the parents communicate, maybe comes up with suggestions, but the mediator does not make a decision, and the mediator does not give legal advice, but they can kind of help the parents communicate. They can kind of help the parents articulate what their concerns are, what their desires are, why they are looking for a certain custody situation or opposing a certain custody situation. So they can just kind of help with the communication, and a lot of times they can help the parties come together. So that's it. That's question 11 through 20 of the most frequently asked questions about divorce in Nebraska, according to ChatGPT. Thank you for watching the video. I hope you found it informative. Again, if you are in the middle of a divorce and don't have an attorney, or you are contemplating a divorce, I would encourage you to speak to an attorney about your situation. Every case is going to be a little bit different. Not every marriage is the same. Not every divorce is the same. If you are outside the state of Nebraska, again, some of those answers are going to be maybe different than what they are in Nebraska. And so you should speak to a family law attorney in the state where you live. Thank you very much, and until next time.